Excited Utterance, the Evidence and Proof Podcast, Episode 151, Teneille Brown and Emily Murphy, Expert Framework Evidence. Welcome to Excited Utterance. I'm your host, Alex Nunn, from the Texas A&M University School of Law. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence and proof. We bring virtual workshops to you throughout the academic year. Today on Excited Utterance, we have another special episode with two amazing guests. Our first guest is Teneille Ruth Brown. Teneille is the James Farr Professor of Law at the University of Utah's S.J. Quinney College of Law. Teneille is also the director of the Center for Law and the Biomedical Sciences. Joining Teneille today is Emily Murphy. Emily is a professor of law and the Harry and Lillian Hastings Research Chair at UC Law San Francisco. Now, as many law professors will know, both Teneille and Emily recently made waves in the evidence community by filing an amicus brief in a pending United States Supreme Court case, Diaz v. United States. And, as you'll hear in my conversation with Teneille and Emily today, their brief encouraged the Supreme Court to recognize that expert testimony, what's referred to as framework evidence, and Federal Rule of Evidence 704, they're all reconcilable. Now, that might seem like something of a complex topic, but Teneille and Emily today do a fantastic job of explaining the key issues and also demonstrating why their intervention through their amicus brief is so essential. I was ultimately thrilled to be able to sign on to this brief myself alongside dozens of law professors nationwide, and I hope you enjoy my conversation with Teneille and Emily today about Rule 704 and framework evidence. Teneille, Emily, welcome to Excited Utterance.
Thanks so much for having us.
Of course. I'm thrilled that you're here, and I'm especially thrilled because today we really have a super exciting podcast because in what I think, I'm pretty confident, I was looking back for the podcast, and in Excited Utterance first, we're going to chat about a recent amicus brief that you both filed in a pending Supreme Court case, Diaz v. United States. Now, to our listeners, I couldn't encourage you more highly to go and actually read this brief. I think it's fantastic. I felt very privileged to be able to sign on to this brief. But before we dive into the substance of the brief, I want to begin just with an initial question. So Teneille, Emily, I'm curious, what motivated you to want to write the amicus brief in Diaz?
Thanks, Alex. Yeah, it's always fun to know the background. Teneille and I have been working on scientific evidence issues for a long time, but I had to go back and look at my email how this started. And I think it started back in November when the court granted cert in this case. And a student of mine who was working on a different project with me on a confrontation clause noticed it on a Bloomberg news blast, forwarded it and said, "Oh, this is interesting, but it's not relevant for confrontation clause." And I said, "Oh, this is extremely interesting for what Teneille and I know about as group to individual inference issues and scientific evidence more generally." So I took a look at it, sent it along to David Fagman and said, "This is cool, we should take a look at this." And then connected with Teneille, and she of course said, "Yeah, this is super interesting." And Teneille took the initial laboring oar on drafting in January. We missed the deadline. In a real transparency here, we missed the deadline to file on behalf of neither party because we weren't closely tracking the deadlines initially. Neither of us have been Supreme Court practitioners. And also the court just very rudely didn't consider the fact that we were spending all of December grading our exams.
Obviously.
But by the time we really sat down to dig into it, it did make sense for us to come in on the side of the government, even though that's kind of an unusual position for pro bono amicus briefs, we know.
Well, I think that's a great story and also highly relatable with missed deadlines, especially around that holiday break. So I think some perfect background before we dive into the actual substance of the brief. So let's maybe do that now. So perhaps as an introductory matter, you could provide us a little bit of background on the Diaz case. What was the case about?
So this case is actually one that I find easier to explain to non-evidence people than maybe some other evidence cases, because it involves facts that are pretty familiar, that involve the kind of things you might see on TV. Delilah Diaz was driving what she says was her boyfriend's car up from the border from Mexico into California. And she was stopped at the border. When the border agents tried to roll down the windows, they heard a crunching sound, which indicated to them maybe something was packed in the doors. So when they searched, they found a bunch of meth. And she was charged under the Controlled Substances Act for knowingly transporting drugs. And so the whole question was about whether she knew that she was carrying drugs across the border. And that was pretty much her entire defense, was that she did not know that the drugs were in her car.
So let me follow up on that point, if I can. You mentioned that the whole case was about whether she knowingly possessed these drugs. Was that the key issue that the Supreme Court granted cert for in Diaz, or was it kind of a modification of that question?
I would say it's a modification of that question because it involved a particular evidence rule called 704B. So the issue was the state brought in an expert, Agent Flood, who testified to what most drug cartels did. And he said that most drivers know there are drugs in their vehicles, that the drug cartels don't like to use unknowing couriers because the value of the meth was just too great and they're not going to risk it on someone who doesn't know that they're carrying it. So they introduced this expert testimony to say that most drivers know that there are drugs in their vehicles. And that was the particular piece of evidence that was challenged as violating this Rule 704B.
Perfect. So, kind of building on that, we have Rule 704 and we have this expert testimony. Let's first explore Rule 704, then we'll turn to the expert testimony. So, under Rule 704, and this might just be good information for listeners who don't have an evidence background, but are experts typically allowed to testify directly about what a particular defendant's mental state might be?
No, so Rule 704 is, let's start from the broader rule itself. The rule is titled Opinion on an Ultimate Issue. And Part A tells us that in general, such an opinion is not objectionable just because it embraces an ultimate issue. And we should explain for listeners what is really meant by ultimate issue and what is not meant. But this case concerns the exception to that rule, is Rule 704B, which states, and I'll just read the rule, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone.
So you just mentioned the ultimate issue rule under Rule 704. If we could, let's circle back to that. What exactly is the ultimate issue rule for those listeners who might not be familiar?
Yeah, so the ultimate issue rule was a common law rule, and it began because of the concern that experts would be telling juries how to decide cases. So the ultimate issue was some fact that goes to the heart of a fact that the plaintiff or the prosecutor would need to prove. So at common law, experts were not allowed to testify to whether, say, a defendant was drunk. If they were being prosecuted for public intoxication, they would be able to draw the line and say, yes, in my expert opinion, this person was drunk. They couldn't say that a defendant was speeding if they had been charged with reckless driving, and speeding was the kind of key piece to prove that. So everything goes back to this idea that the experts were not supposed to tell jurors how to decide an ultimate issue. So one of the facts or the elements that needed to be proved. And it turned out that that deprived the jury of a lot of useful information, because if you have, say, an expert physician in a negligence case who would be testifying to whether the defendant's breach caused some injury, causation is an ultimate issue in the negligence tort. And the expert would not have been able to opine on whether he thought the defendant caused the injury. And so that was something that was really missing, where courts thought juries need to be able to hear that. They need to be able to hear the expert's opinion on the ultimate issue, or in the case of, was the defendant speeding, was he drunk? And so the common law rule was thought to be unduly restrictive. And so it was abolished with Rule 704A, which allows experts generally to testify on ultimate issues.
Now, Rule 704B was an exception that arose in response to the public outcry after John Hinckley's acquittal of, I think, his attempt to assassinate former President Ronald Reagan. And when there were dueling experts testifying at his trial, specifically about his legally relevant mental state, whether he was insane or whether he had the mental capacity to be culpable for the attempt, the congressional response to that was to put this exception in. So the specific exception applies only in criminal cases. It applies to mental states or conditions that are an element of the crime charged or notably of the defense. But the issue in this case, the question presented and what the court is going to have to decide is the scope of what is really meant by what's an opinion about the mental state or condition. It's quite clear that an expert getting up on the stand and saying, this defendant was insane at the time would be prohibited by the rule. And that makes sense to us, both in terms of that's easily prohibited by the text of the rule, but also it's just not, as we point out in the brief, it's just not something that people can do with a high degree of expert certainty, is say what someone's individual past mental state was.
I think that's a fantastic recap of Rule 704. And now I want to transition to what we discussed earlier in the podcast, which was that expert testimony, or what the court in Diaz refers to as, and what you refer to in your brief as so-called framework evidence. So tell us more about framework evidence. What is that?
So framework evidence is off-the-shelf data that are just describing facts in the world. They could be describing groups about how people who are part of drug cartels tend to behave. They could be describing how women who've been battered tend to behave. And so it's group data that explains a phenomenon that just exists in the world.
Framework evidence is a really useful heuristic for understanding what the evidence is. And it was developed, and a concept developed starting in the 1980s by John Monahan, our chief signer of the brief, and Lawrence Walker, who kind of noticed that this category of group-based data or context-based data doesn't really fit the previous sort of the understood binary of adjudicative facts and legislative facts. Adjudicative facts being like, what exactly happened in this case? What was the mental state? Or legislative facts are abstract empirical data that guides policymaking. Framework data is kind of straddles the two, is extremely useful, not just in an adjudicative evidentiary context, but is actually how people make decisions about their life all the time. If you're a Bayesian, if you're listening to this podcast, you might be a Bayesian. It is your background priors, or it updates your priors before you make a decision about a given particular situation or fact, because it is information about how the world works generally. So one thing about framework evidence that came up in some of our discussions surrounding this brief is whether framework evidence has to be supported by scientific evidence. And the answer is not really. Framework evidence is conceptual rather than kind of specific. So some perspectives on this might be, well, the framework of cop experience is not data. And it's like, well, it is, experience is data. It's not what we would consider numerical data. It's not a double-blind, randomized controlled trial type of data, but it is empirical. Experience is empirical data, and it can add up, even if we might consider it more qualitative than quantitative. It's still empirical in the sense that it is data about the world. But framework evidence doesn't have to just be what we would term scientific evidence. Framework evidence can be based on knowledge and experience, which fits perfectly within our conceptions of expert testimony. Expert testimony doesn't, and Rule 702 doesn't just deal with scientific expert testimony. We know from Kumho Tire that expert testimony encompasses technical knowledge, experience, expertise, learned, a broad range of real world life experience, and framework evidence can apply to all of those.
So in your amicus brief, what do you argue about framework evidence? Does it invade the realm of the jury in your view? Does it violate Rule 704, or is it potentially permissible?
Yeah, so it definitely does not have to invade the role of the jury. In fact, the argument that the petitioners made that introducing this kind of class-wide, what they called class-wide mens rea evidence, that it is the functional equivalent of telling the jury how to decide an ultimate issue like mens rea, that really proves too much, because if you do not allow framework evidence in this case, there's so many cases that are very, very close to providing direct evidence of mental states that you just have to change the phrasing in a very slight way. So just to go to the petitioner's reply brief here, they're talking about how there's this problem with the agent flood saying most drivers know there are drugs in vehicles. Like, that's the problem. And so they said, but it would be okay to say something like, most drug organizations use drivers who've been told about the contents of their car. And that kind of subtle difference is going to be very difficult for jurors to not automatically infer a mental state. And the same is true anytime you hear about how somebody has behaved. So if we can't bring in class-wide mens rea evidence, there's one big question of like, well, then how is the jury going to infer mental states? Because that's how we infer mental states, is based on behavior, circumstantial evidence. And this is just framework evidence that is circumstantial evidence of what people may have thought. But I think framework evidence, it doesn't invade the role of the jury because it's just group data. And the jury is the one responsible for connecting the dots and saying, is this individual a member of that group, first of all? Which the petitioners, we should talk about that too, in their reply brief. They didn't understand the argument we were making there, I don't think. But the first step is you have to say that the jury gets to decide whether the defendant in this case is a member of the group that is being described in the framework. And then does it apply to this person? Do we think that maybe there's some reason the cross-examination really pulled out the idea that Diaz maybe didn't know, that maybe this is what groups tend to do, but there's something unique about her that means that maybe she in particular did not know. There was some testimony by a friend, some cell data evidence, something to suggest that she really did not know. And so there's a two-step process that the jurors have to engage in that allow them to make the final call. Is this an instance of the group? Is Diaz a member of this group? And does the framework evidence that I'm hearing make sense and fit with her? Does it apply to her?
And following up on one thread, you mentioned that the petitioners perhaps didn't understand your argument in their reply brief. I'd love to hear more about that.
Yeah, they were talking, it's in footnote 5. Amici law professors suggest that juries also be instructed that they should consider whether the defendant was truly a member of the group to which the expert testified. And then they go on to say that this case illustrates that that doesn't add anything because Agent Flood defined the relevant class as all drivers crossing the border with large quantities of drugs. That's in fact not the group. They missed the whole framework. The group is not drivers across the border. The group are people who are part of drug cartels. And so the question was, the jury still gets to decide whether Diaz was part of a drug cartel. And they really seem to miss both that fact of like, what is the group data that's being presented? It's not about drivers across the border. It's about, was she a member of a drug cartel? And this is how drug cartels tend to behave. But they seem to misunderstand that when you provide framework group evidence, the jury can take it or leave it. The jury can decide this framework doesn't seem legit. I don't think it's based on much. It seems very thin. They could challenge the reliability of the data itself. They could say, I think that the defense did a really good job removing Diaz from that class and saying she was not a part of this drug organization. And the jury ultimately gets to decide that. But the petitioners seem to really downplay the role of things like cross-examination, said that the defense would be powerless to respond to a state expert who said this kind of testimony, like what Agent Flood said. And I think that just really shows their hand as not maybe being criminal law practitioners. And I'm not either, so I should be clear about that as well. But cross-examination could effectively destroy this framework evidence if it were really the case that Diaz were not a member of the group. They could say things like, okay, so Agent Flood, this is how drug cartels tend to behave in your experience. They tend to know, they only use couriers who are aware or knowing about the drugs that they're carrying. But you never have met Ms. Diaz, right? No, I've never met her. This woman who's sitting here at the defense table, you don't know anything about her, right? No, I've never met her. So there are ways to really sever that tie to make it clear that the jury gets to decide if she's a part of that group and if the testimony applies to her. Yeah, so one other thing that I wanted to address is the idea that this petitioner's argument in the functional equivalent test would actually backfire against criminal defendants. So even in the context of drug trafficking cases, it's often the case that defendants introduce evidence of the amount of drugs that were in their possession to argue that this was an amount that would be used for personal use, and that if they had been trafficking in, say, meth or cocaine, they would have had quite a bit more. And so this kind of framework evidence about what the amount of drugs people usually have is for personal use is really common. It's a common defense to say the amount I had was just for me to use and I was not selling it, so you can't prosecute me for distribution or sales. And the petitioner's argument would prevent defendants from bringing in that kind of framework evidence because it goes to their mental state of knowledge and intent to sell, and their intent was just to use it for personal use, and that framework evidence would not be allowed. So I think there are a lot of cases where the defense argument really, in the long run, if you took it to its logical extension, it would eliminate a lot of really helpful defense framework evidence.
There are criminal defense practitioners in the other amicus briefs who also don't like this. They don't like the Ninth Circuit's rule. They prefer the Fifth Circuit's functional equivalence rule that would eliminate such expert testimony. But we think that their grounds for doing so is really based on what they view as the unreliability of cops as experts. And that is a very large, very important, and entirely separate issue from the question presented. So it's not one that our briefs deal with. But just to address the National Association of Federal Defenders and the National Criminal Defense Lawyers Association, I may have the acronym wrong there, both to varying degrees say there's just no countervailing expert we could bring in. What are we going to do? Find a retired drug cartel person to say, no, actually, we do use this. And we want to underscore, yes, that is true, but also the cross-examination that can be done to, as Teneille pointed out, sever the link between what the expert who's testifying to the framework about what drug cartels generally do and their knowledge of this particular person. Those should be entirely separable if you have an expert who is not involved in the investigation. If the expert was involved in the investigation, now we have dual role testimony, and that's an entirely separate issue that deserves its own set of examination, Supreme Court case. And again, the reliability of whether as experts are reliable, that's a 702 question. The reliability of cops as experts is a really important issue that's just not presented in this case. It wasn't even preserved. There was no 702 objection raised at trial, even when the court asked defense attorney if a 702 objection was forthcoming. So as much as we had a listserv discussion among evidence professors about those issues, this just simply isn't the case presenting them.
Yeah, I feel like the 702 issue is really looming in the background here. And so I'm glad you brought that to the fore, because I think the petitioners were sort of shadowboxing with the unreliability of Agent Flood's testimony, even though the reliability of his testimony was not at issue. It was not a preserved issue. It was not challenged at trial, but they seem to be really trying to fight this issue of cops as experts. And so I do think there's something to the argument that it's harder to deflate a cop expert, maybe in the eyes of some jurors. And so there probably is a concern that they're just speaking from their gut. They can't talk about their methodology. They can't talk about some of the things Emily mentioned of like inclusion criteria, exclusion criteria. And that is an issue, but that is a separate 702 issue.
And I really like this line of discussion, both that Emily raised and that Teneille, you just commented on, because I also think it implicates a broader issue in the background here. So zooming out, it seems to me that Diaz is kind of ultimately grappling with this core tension between expert testimony on the one hand, and then just the adversariality of adjudication on the other, trying to preserve that adversarial process. And that's, of course, a huge issue. As Emily mentioned, we're going to need many Supreme Court cases, I'm sure, to fully reconcile this. But do you have any, at least initial thoughts on how the Supreme Court might help manage that tension between expert testimony and the adversarial process?
That tension goes back to Daubert and 702 and courts being expected to be gatekeepers of some threshold level of reliability and validity, even though those terms are misused in the legal cases itself as compared to what scientists really understand. But there was a recent amendment to Rule 702 to re-emphasize courts' gatekeeping role by requiring that courts assess that reliability validity by a preponderance of the evidence. Courts had been, frankly, kind of punting on it for a long time. And that might still happen in trial courts because courts struggle with assessing reliability and validity of expert evidence. But how might the Supreme Court help? We think that they could help by adopting our brief, that by adopting and interpreting this rule to encompass a framework to diagnostic, or we also call it group to individual inference, and say, this is a way to reason from background, context, and group-based data to individual, and explaining to trial courts that this is the type of reasoning that has to be done, and how having trial courts, I mean, the Supreme Court doesn't prescribe jury instructions, but kind of, even in dicta saying this is how this could be done. Giving guidance that can be broadly applicable across a range of different cases. I mean, 704B applies to all criminal cases, but the question presented could be construed very narrowly. The question presented in this case is, in a prosecution for drug trafficking, where an element of the offense is that the defendant knew she was carrying illegal drugs, does Rule 704B permit a governmental expert witness to testify that most people at the border with drugs know they are carrying those drugs and that drug trafficking organizations do not entrust large quantities of drugs to unknowing couriers? Okay, so the question presented deals with a specific type of case, drug trafficking, and with experts from one side, government experts. I think the Supreme Court could potentially make a big mess of and help no one by actually trying to promulgate a narrow ruling for a specific type of case with a specific type of expert, because 704B questions have already come up in even in the Fifth Circuit in cases beyond drug trafficking. There will be inevitably, well, what do we mean by drug trafficking? Do you mean by human trafficking? Like where are the boundaries of such a narrow ruling? And the rule itself applies to experts offered by the government, but also experts offered by the defendant in an affirmative defense. Maybe it would be less messy to say, okay, this rule has to be interpreted differently for a specific type of government expert, but that's just going to create confusion. We really think that there's a way to solve this by adopting evidence framework to teach courts and teach juries how to consider the evidence that is relevant, that is, if it's reliable, that how to make sense of it with the task at hand.
Well, I just have one final question for you, and that is our classic last question on Excited Utterance. What's next for the literature? Is there a type of paper or maybe even another brief that would help inform courts or shed additional light on this issue?
So I actually think the next step involves things not related to 704, but definitely what came up in this conversation. One would be something around how we translate our scholarship into advocacy and how we do that, how we think about doing that, when it's appropriate, what kind of arguments seem ethical to make, because there were a couple of times in this process where I found myself making an argument based on the state of the world as it is, but I've argued separately for changing the state of the world. And so it's like, do you argue based in kind of the playground that you're in and the world you're in, or do you try to push and say, maybe we need to be changing things? So that was the big question, I think, just in terms of how we translate our scholarship into advocacy and how we think about that. I do think there's another big meta paper to write about just the process of jury inferences and how we can get up right to the line of encouraging a jury to make an inference or acknowledging that a lot of inferences are automatic. Like a lot of these mental state inferences happen spontaneously, automatically. And so the idea that we can regulate them with really careful phrasings, and we're going to say that most drug organizations inform the drivers that they're carrying drugs. Well, how is that different from saying most drivers know? Do jurors understand that to be a difference? I think it'd be very cool to do some empirical research on that, because my very strong guess is that those are interpreted in the exact same way. And so I think something about doing some research on how jurors actually make these inferences, and maybe there is something like the functional equivalent. Maybe there really is an idea that you tell someone something and they're going to interpret it as, this is the way we're supposed to decide this. But I highly doubt that, because I do think that jurors understand that they don't need to believe everything they hear, and that if someone tells them that this is how most people behave, they may not believe the defendant. They may not believe the witnesses who speak on the defendant's behalf. And there's really still a lot of room there for advocacy. So I would say something, maybe an empirical paper on how jurors draw inferences. I do think there's maybe even a third paper on how we have this dual view of jurors. I think this amicus brief really shows how we're kind of two minds about jurors, that we think they are incapable of dismissing expert testimony, that there will be this functional equivalent where they're just going to uncritically assume whatever the expert tells them. And then on the other hand, we obviously empower jurors to make the ultimate decision about guilt and to decide things like damages and in some cases sentences. And so it's like, well, which is it? Like, I think this is a fundamental problem with evidence law, is we don't really have a consistent view of the juror. The juror is both incapable of drawing these inferences on their own, but then has to make the ultimate inference, kind of the ultimate call.
So I just want to pick up on the first thing that Teneille was talking about translating scholarship into advocacy. This was the first time either of us have done anything like this. We enjoyed the process so much. We've worked together before. We really enjoyed collaborating.
It was delightful.
It was so fun to work together.
It was really fun.
It was really fun. It was fun for me to dust off the litigator skills and fun for me to work with Teneille always. But there's a really interesting question more generally, which we had lots of side conversations and emails about with folks who signed and folks who considered signing about what is the role of amicus briefs for the court, especially professor amicus briefs, and getting a glimpse into this world with this project, which we think comes at it from a very truly academic perspective, and an academic perspective of this is how the rules of evidence work as a whole. This is how the rules of evidence should work from a epistemological point of view. But we don't really have a dog in this fight. We're not a defense bar. We're not the government. That this brief could have also been appropriately filed on behalf of neither party, even though the result in this case comes out in support of the government. But we encountered a really interesting and wide range of viewpoints about what is the proper role of the academy in filing amicus briefs, and what kind of amicus briefs are truly friendly to the court in the sense of trying to help the court solve a difficult problem and not weighing in as an additional advocate for a particular outcome. I think our position could lead to a wide range of outcomes, as we say in our brief. We also think in many cases it would be defendant protective. But there's a range of views on it.
Probably in more cases, actually. I think it's more likely to bite defendants if they take petitioner's view.
But there's a range of views on this in the academy, and I think two things. One, there's so much good evidence scholarship. There has been so much good evidence scholarship. There's currently so much good evidence scholarship that could be truly helpful to the court. The court doesn't frequently grapple with evidentiary problems, but they're not minor technical issues. They're major transsubstantive things that affect a lot of different types of adjudication. So I don't think they should be viewed as little technical things that I do think that the Evidence Academy should keep an active eye on cases. Particularly, we all would like to see more confrontation clause cases in that kind of doctrinal mess get resolved, and we should help. We should help resolve them from a considered, scholarly, outcome neutral viewpoint. But that's not the view of everyone in the academy. And so the second point I would have is we should talk as an evidence bar about what is the role of professors and different groups of professors, different viewpoints from the professoriate about which side to support. We got a lot of pushback from some, not all, but some former defense bar folks who said, in essence, like, how could you be coming in on the side of the government? Which is a different and unique position for the academy, I think, broadly speaking. But we should be having those conversations, and we should be having perhaps symposia, perhaps workshops, perhaps evidence summer workshop to discuss what is the role of faculty, what is the role of scholarship, and to both bring justice, bring outcomes that we think are just and fair, and also ensure process. And I think in evidence law in particular, those things sometimes feel in tension for people.
Well, following up on that point, I think that those are excellent comments, Emily. And we actually have, I think, both of you scheduled for the Evidence Summer Workshop in early May in Nashville. I believe that we're going to have a plenary session on this very issue, your brief, and kind of that broader topic of the role of the academy in terms of interfacing with courts. So that's certainly something that I'm very much looking forward to. But I want to thank you both so much, not only for this excellent podcast, but for writing this brief. From my perspective, I think that you've done a huge service to the academy and that the brief was excellent.
Thank you for signing it.
Of course. Yeah, I was happy to sign it.
We also definitely need to thank Professor Matthew Coles, who is my colleague at UC Law SF, who is a legendary civil rights litigator and a member of the Supreme Court Bar, who was our counsel of record in the case here. And we also had, I just want to plug this, phenomenal research assistance from UC Law SF student Caleb Kelly, who was really on the ball in January when we were writing this. Couldn't have done it without him. And
absolutely.
Also was super helpful.
Awesome. Well, thank you so much for discussing your brief, and I look forward to that evidence summer workshop.
Thanks, Alex.
Thanks, Alex.
So, to my mind, Teneille's and Emily's brief raises so many questions for evidence professors to consider. Of course, you have the primary substantive questions. How can you reconcile Rule 704 with framework evidence? For my part, I think Teneille's and Emily's argument is exactly correct, particularly when you recognize that the Rule 704 question is one of admissibility, it's not one of weight, and it's not one that focuses on reliability, which is relegated to Rule 702. But I also think that Teneille's and Emily's amicus brief gives us evidence professors an opportunity to consider a higher order question, one that I believe Teneille raised at the end of our podcast there, which is this. How should evidence professors interface with courts? How should evidence professors engage or not with amicus briefs? And here, ultimately, I don't think there's going to be a one-size-fits-all answer. I think different professors will have different perspectives on whether joining an amicus brief is advisable or not. And of course, there will be differences based on substantive disagreements, but what about differences just based on the practice of signing on to amicus briefs? Is it our duty as evidence scholars to try to help the court best understand a particular evidentiary issue? Is it advisable for evidence professors when crafting an amicus brief to try to be more formalistic and really just discern how the federal rules of evidence operate in practice? Or should evidence professors be more realist? Should they be consequentialist? Should they think about the interpretation of the rules that might yield the best consequences in practice? And ultimately, in amicus briefs, should evidence professors defer to the state of evidence law descriptively as it's found out in the real world today, or should we use amicus briefs as an opportunity to try to improve evidence law, to try to channel it to a better form? These are tricky questions, and as I mentioned before, I don't think that there will be one shared answer to these questions among the legal academy. But at the same time, I feel like it's very important to engage in a dialogue about how we as evidence professors should approach amicus briefs. And as Emily and Teneille mentioned, and I'm excited to emphasize once more, that conversation is at least going to begin at the Evidence Summer Workshop on May 15th through the 17th in Nashville, when Emily and Teneille will have a plenary session with the Evidence Academy discussing these exact questions. Ultimately, though, I want to thank Teneille and Emily once again for coming on the podcast. I thought that they did a wonderful job of unpacking these issues in Diaz, unpacking framework evidence in Rule 704. I was thrilled to be able to sign on to their brief, and I hoped you enjoyed our conversation today. Support for Excited Utterance is generously provided by Vanderbilt Law School's Brandstetter Litigation and Dispute Resolution Program and the Texas A&M University School of Law. The producer is Ed Chang, and the production editor is Madeline DiPietro. Additional assistance was provided by Tammy Pierce, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm, of course, your host, Alex Nunn, and I hope you will join us again next time when we take on another work in the world of evidence and proof.